But we are right at 3 o'clock. Hello, everyone. My name is Alan Hensley. I am a wealth advisor here at Financial Insights Wealth Management. Thank you for joining us today for the Wisdom and Wealth webinar. This is our second one of the year. And we will have this presentation will be presented by local attorneys Keara Bennett and Amanda Nathan of Gordon Thomas Honeywell. Keara and Amanda are experienced estate planning attorneys who help clients navigate wills, trusts, probates with care and clarity. And together they offer practical insights and expert guidance to help you plan confidently for the future. So this presentation should take about 45, 50 minutes. We'll try to leave some time at the end for questions. So just know that we're going to try and save some time at the end. And then with all of that said, there's a lot of great stuff to get into. So I'm going to turn it over to Amanda.
All right. Well, thank you, Alan. I'm glad to be here. Hopefully we won't put you all to sleep today with this really exciting topic that we've got. But I think we'll try to keep it, helpful and hopefully engaging. So Keara and I, as Alan mentioned, we do a lot of estate planning. We also handle probate and a number of trust matters in our daily work. And as we're going through the slide deck here, I do welcome questions. As Alan said, if there's something really pressing that you want to throw in the middle, I don't mind being interrupted, but let's kind of probably try to batch those at the end if we can, see if we can get through this. Have a rather ambitious slide deck, I think. Okay, give me a moment here. We didn't practice this, Alan. We didn't try screen sharing.
Oh, that's right. Let me know. I can share it if we need to.
1 second. Sorry. Stop it. Screen share. Practice everything else.
And let me know if the host, Jordan, you might have to give her the sharing hours, but.
I'm going to share this before I go to the slideshow. And then we'll go to slideshow. Right. How's that looking?
Great, Alex.
Okay, good. Thank you. All right. So we're going to talk about navigating estate transitions. What no one tells you, or maybe somebody has told you, but you kind of forgot because it's been a while and these are, it's often a difficult time, lots going on. And so maybe by talking through some of this today, we can help ease that anxiety if you're feeling a little anxious about what would happen, and also help you think about some topics to talk about with your own estate planning attorney and with your financial advisors as you're working on your own planning. Disclaimer, first of all, that I am not a tech wizard, so I apologize. Secondly, that we always have to just remind you all, we are not providing this today as legal advice. This is just some information we hope will be helpful to you if you're doing your own estate planning, or if you're in the middle of an estate administration, questions you might want to take back to your own legal counsel. Okay? Get that out of the way. And to that extent, if you have specific questions, I'll probably try to sidestep a little because I'm not able to advise you individually in this setting. Overview. This is what we're planning to get through in the next 45 minutes or so. After a death, sort of some first steps, sort of where do you start? When there's someone that passed away, you might be the executor or personal representative under their will. What do you do? Who do you call? What happens next? We'll try to touch on that. We'll talk about different approaches to estate administration. There are, will-based plans. There are revocable living trust-based plans that have a lot of similarities, but a few distinct differences. There's intestate estates that are handled without a valid will if we don't have a will. And there's also this concept of a probate asset versus a non-probate asset. So after today, hopefully, if those are new terms for you, you'll have at least a little idea of what that means. We will touch briefly on taxes. We're not going to talk a lot about this topic today because there's full presentations on this, but we'll give you a little sense on estate taxes in particular, and also kind of remind you that we have estate income tax and the decedent's income tax to keep in mind as well. And post-mortem estate planning is, if we have time for it today, sort of the idea of after a death, particularly if it's the first spouse to die in a married couple, there are some things we can be talking with our clients about, on how to, what are the next steps in the tax planning in particular. That's an opportunity to do some good planning. All right. Here, I think this is you.
This is. All right, so as Amanda said, we're in a situation now where perhaps you're a personal representative of an estate and someone's passed away, and now it's your turn, right? It's for your turn to do the lifting. So where do we start? I think it's incredibly important first to realize that you need to take care of yourself emotionally and your loved ones, right? If this is a loved one that's passed away, you absolutely have the time and the space to take a second, take a breath. After this, it's important to locate the original will, any other relevant documents. This might be codicils, a living trust if there isn't, if there is a will-based plan or if not, as well as any disposition authorization. A disposition authorization is a document that outlines what you'd like to have happen to your physical self. Washington has 4 different options, which are probably outside of the scope of what we're going for right now. But it's important to know that you have options, and outlining what you'd like to be done really saves your personal representative the fear of having to figure out what you might want to have had done. It's also incredibly important as the personal representative that you secure the decedent's home and personal property. Even before before we start the probate process or anything happens. Your loved one has passed away or the person you're close to has passed away, and it's your job to ensure that nobody is going to break into the home, take their things of that nature, right? So ensuring that you have keys or that you know where keys are, locking down the house, and making sure things are secured. There's also a note, park the decedent's vehicle in a safe place until insurance is confirmed. As the personal representative, you have a duty to keep such things, insurance going, right? But we want to make sure that we have the car in a secure location while we work on that and make sure that it's still paid for. You'll collect the decedent's mail, continue to do so. It's actually really important that you start collecting that mail. It's going to start to help you piece together what's going on. In the best case scenario, it's all laid out and you know exactly what's happening and where you need to go next, but very rarely is it the best case scenario. So mail is a great place to start. Mail is a great place to start to figure out, okay, they get, letters from Charles Schwab. They get other mail from this bank. I know that I need to contact these people to figure out what's exactly going on in their estate. And of course, it's always important to contact a trust and estates attorney, a qualified trust and estates attorney, for assistance with the next steps. And do not rush to retitle assets, especially let's say you're a surviving spouse. Your spouse has unfortunately passed away. It's fairly possible that you have the authority to start moving stuff around and retitling everything. Well, it's important to take a second and talk to someone first. There's a very fair possibility or a very real possibility that your estate plan depends on some of those assets. So taking a second and not moving things around can be really important. Okay, Amanda, there we go. So the estate, oh, go ahead.
Thank you. I think I got this one. Estate administration, we had three things we're going to talk through. I mentioned them previously, but we'll start with probate estate. Probate, that term I think has a lot of connotation. Some folks have heard bad things about probate. They often come to me and say, I've been told I need to get all of my assets into a trust to avoid a probate. What is probate? Court supervised process to settle creditors' claims of the decedent and distribute assets of the estate. That's the formal answer. Typically here in Washington, the court involvement in the probate is right at the front of the process. You actually, as the personal representative under the will, if you're named in the will, as the personal representative, which is the same as the executor in some states, we would call it the executor, you petition the court to be appointed You petition the court to admit the will to probate and then to be appointed as the personal representative or administrator of the estate. Once the court grants that petition, you get letters testamentary, which you can carry around to the bank, the Department of DMV to retitle anything you might need to be retitling. You've got your letters with the court's blessing saying this person is authorized to act on behalf of the estate. And for most of our probate, that's basically the end of the court's involvement. We get the letters, we go do our work, we help the personal representative settle the estate. We're going to talk through that process, and then we close the probate when we're done by filing closing documents with the court, but we never actually go back to court. And so I think in Washington state, probate's pretty straightforward, and we'll talk more about why we don't think it's a scary thing. Intestate versus testate estate, we'll talk about a will-based plan, which is a testate estate, if the decedent had a validly executed last will and testament, or an intestate estate where there is no will, or at least you can't find a will, or the will is not validly executed. There are some formalities required under state law for a will to be valid, like a notarized document, probably not going to cut it. So there are certain things that we would be looking for it to meet that criteria. We'll talk about living trust. A living trust is a revocable document that you can change anytime during your life. It's a tool that you'll see used in many places, and here in Washington as well, but it's used to avoid having a probate that you have to go to court to open. But it doesn't always avoid a probate. We'll explain more where the failure can happen. And then we'll talk about non-probate assets. There are quite a few assets that actually can pass completely outside of both of these things. So your last will and testament, your living trust, surprise, it doesn't actually control all of your assets. There are these things we call non-probate assets, typically your retirement account, life insurance, that will pass by a totally different method. So when we do estate planning, when we're administering an estate, we're looking at all of these things. I'll briefly talk about a little more about the testate estate. So we've talked about validly executed last will and testament. This is your plan that you have spent some time putting into thinking who's going to manage your estate after your lifetime, who's going to inherit your assets, and how are they going to inherit them? Outright, in trust, in a custodial account for young people. Typically, your personal representative, if you've got an estate that it's solvent, it has more assets than debts, and if you have a valid will that was well drafted, your personal representative will likely be appointed by the court with non-intervention powers. That means the court isn't going to come back and ask them for much of anything except for maybe a status report to show them that they're.
I'll try F10.
No.
Just a status report if your probate's open for some length of time, but the court wants to know that you're making progress. The personal representative will receive the letters testamentary. As I mentioned, that is basically a one-page document that says this person, Amanda is authorized. This is the personal representative duly acting on behalf of this estate. And that is something that will get you pretty far with banks and brokers typically in administering estate assets. It can clear up a lot of confusion. The duties of the personal representative. This is a short list. I've tried to summarize, but essentially notifying the heirs of the estate. That would be both folks who are named in the will and folks who might be intestate heirs. So let's say there's a child who's disinherited. They still get notice of the estate because they're an intestate heir under state law. And if they want to challenge the validity of your will, they have to have had notice of the estate to be able to exercise that right? So we notify all of your heirs, testate and intestate. Then the personal representative marshals the estate assets as a fancy way of figuring out what the decedent owns, what it's worth, tries to get control of that asset so they can safeguard it and manage it responsibly on behalf of the estate heirs. Compiles an estate inventory. That's where we nail down the valuations as of the date of death. Settle the debts and pay taxes owed by the estate. That's an important part of any estate administration process, but through probate, we would do that as a standard course of operating procedures. So settling the debts would include trying to identify creditors of the estate and settle those debts before we close the probate so we can move on with a clean slate. Finally, distributing assets to the heirs that are or the beneficiary's name in the will. Assuming we don't have any will contest, or at least no successful will contest, at the end of the day, the beneficiary under your will would be receiving whatever assets are left after the debts have been paid, taxes have been paid up. Another point on a testated estate, you will see what you might hear. So if you're reading on the internet, you might read about testamentary trust. There are lots of different types of trusts out there. We're going to talk about revocable living trust. But this list here, these are types of irrevocable trust. Often you would see these funded after a death per the terms of the will. The will might have a trust in it called a marital trust for the surviving spouse's lifetime benefit. So the language might say something like, I'm leaving my assets, the residue of my estate in trust for my spouse for life and then to my children. Okay, something similar to that. That's what we probably see most often in Washington because we do have an estate tax in Washington, and this marital trust is a big part of good tax planning for Washington residents. But there are other reasons you might use them as well. You'll see testamentary trusts funded for young beneficiaries under certain age, maybe under 25, under 35. You would fund a trust for them rather than giving them their inheritance outright. You might have a special needs trust or a supplemental needs trust for, and it could be an adult beneficiary who just has, health issues that make it difficult for them to manage their assets or require them to receive government aid for basic housing and living cost of living, and we don't want their inheritance to have to be spent down, for example, for them to qualify for that aid. So there's special needs trust for that situation. Spendthrift protection for kids who are completely bad at managing money. That happens, often. And unfortunately, in our practice, we see that concern come up. Charitable trust, generation skipping trust, the dynasty trust that makes me think of like a Netflix show, but where you're leaving wealth to, you're skipping your children's generation. You're passing more wealth down to your grandchildren, great-grandchildren. You can do that for a while with good planning, actually, without it being taxed again in the next generation's estate. Pet trust. I have done these for dogs, horses. People have very important, animals that in their lives, and they want them taken care of. And if there's enough money in play, we might suggest a trust for the animals. These can also be created under a living trust. But if you have an intestate estate with no will, then you won't be able to do this kind of complex planning. All right, Keara.
All right. So now what happens when there is no will or revocable living trust, or there was one, but it was not valid, right? So this is what's called an intestate estate, and the state law controls the distribution of assets generally. If you don't set up your own estate plan, the state makes one for you. The surviving spouse usually receives 100% of the marital community property and 50% of separate property assets, whereas children, depending on the scenario, can receive 50% of separate assets as well, or separate property. If there is not a spouse, then the estate will pass to living descendants, and those would not include stepchildren, things of that nature. It would include adopted children. If there are no children or descendants to speak of, grandchildren, etc., then your surviving parents, if you have them, or your siblings, or their descendants. So without proper planning, an intestate estate can pull in a lot of different people that we might not expect, right? One really might not expect to think that their nieces and nephews could benefit from their estate, but it's a fair possibility if proper planning isn't done. Let's see, probate is required unless the estate value is less than $100,000. with no real estate. Then what's called a small estate affidavit is available, but that's relatively rare, especially now with the, most people own a home, or if they don't own a home, I would say that under $100,000 in assets is really not as much anymore as maybe it used to be. The exception for transfer on death deeds, you can put a transfer on death deed on a piece of real property. That basically means that when you pass away, that property passes to whomever is named on that deed. There are some issues with having that be your entire estate plan, right? Unfortunately, we rarely see them done correctly, and that can be a problem. There's also just a benefit in general, certain protections for the person that's administering your estate when you go through the probate process that you don't necessarily get when we're just relying on transfer on death allocations. The administrator is appointed by the court. The law sets up who is generally first in line, and it's normally your surviving spouse, and then it goes down to your children. But you lose the opportunity to say who you would like to administer your estate when you don't have proper estate planning. Usually you can get non-intervention powers to reduce court involvement, but there are plenty of circumstances where the court might want intervention, or at least for the administrator to post bond. And that can get pretty, it's not the biggest deal, but it can get complicated. And it's an additional step that, a person who didn't realize that this was going to be their job now has to take on. You also, you don't get the benefit of special planning for your beneficiaries, apart from perhaps custodial accounts for minors. So if you passed away and had minors that would be your intestate beneficiaries, they might get those in special accounts that keep their money safe. But otherwise, you really don't get to decide if your, child who is better with money gets outright, whereas your child who is struggling with money gets the extra protection of a trust. Okay. So we've talked quite a bit about living trusts in comparison to wills. Our revocable living trust takes the place of a last will and testament as your operational or working document in your estate plan. I think there's a lot of misconceptions about living trusts and kind of what they can do, but they are generally a tool similar to a will. You just do a lot of the work front side of things to get them running and operating. Assets should be transferred to the living trust before death to avoid probate. If your assets are not in your living trust, we have not avoided probate by using a living trust, unfortunately. Now we have to do a trust administration for the assets that are in your living trust and a probate for those assets that are not within a living trust and not for non-probate assets, which we will talk about a little bit later. You'll also, aligned with your living trust, is what we call a pour-over will. This is basically, I like to think of it as a security net. Anything that doesn't go in to the living trust, the pour-over will says we're going to treat it, or we're going to move it into the living trust, and it will go according to the trust parameters. However, we generally have to put this pour-over will through probate to get those assets into the trust and then to administer them through the trust terms. Let's see. The duties of the trustee, again, very similar to probate when we're talking about the personal representative and their duties. You have to notify the beneficiaries. The people that are benefiting from the trust need to be notified that the trust exists. Generally, they will know that the trustor or the person that set up the trust has passed away, but they need to be notified that the trust is in existence. The trustee needs to identify, collect, and administer trust assets, along with how the trust has told them to, right? So the trust outlines, this is what you need to do, and the trustee has to follow that. It will again settle debts and pay taxes owed by the decedent's estate, and then the distribution of assets to beneficiaries is then we'll distribute out the assets to the beneficiaries that are named in the trust. So there's some pros and cons to a living trust versus a will-based plan. I touched on it just a little bit initially, but the pros, you get some privacy. You don't have to file the will and as long as everything's in the trust appropriately, and we don't have to go through probate, you don't have to file the will with.
Wait, the living trust. You
No.
don't file a living trust.
Yes, and I'm saying that as long as we have gotten everything into the revocable living trust, we don't have to file the pour over will with the court for probate. Because really that's kind of where your privacy comes in.
I would say you also could have a lot more detail in your living trust, if you don't mind me adding this. I would say the
Yep.
living trust is also not a public document. Whereas your will, even if we don't open a probate, you still are supposed to under law file the original will with the court, just a will only filing. So folks theoretically could look at your will. Now,
Yes.
will I don't know, but if you've got complex distribution of assets, or if you're just a private person, or if you're somebody with a public, a large public following, that's the main reason we see people, one of the main reasons we see them go to living trust, because nobody gets a copy of the living trust unless they are an interested party, typically a beneficiary. Okay, sorry.
Nope, that's okay. A living trust is also a great place to hold out of state real estate. So let's say I live in Washington, but I own a home in California. Keeping this in my revocable living trust is incredibly beneficial in that I don't have to open an ancillary probate in California.
It just muted.
Oh, did I cut out?
Nope, you're fine. Yeah, it's coming through just fine.
Okay. All right. Sounds great. So yeah, for if you're purchasing property or you own property in multiple states, but you're a resident of Washington, using a living trust is a wonderful way to ensure that you don't have to open multiple estates, or I'm sorry, multiple probate proceedings in different states to deal with that real property. There's also a benefit for asset management when worrying about incapacity. So as you age, you may become incapacitated. Your trustee and everything that you own should be generally dealt with in this trust. So your trustee is in a very beneficial space to help manage those assets. And we don't have to, sorry, the chat was distracting me for a second.
No, you're fine. You're coming through just fine. I apologize if someone can't hear us, but the audio is working just fine. So maybe it might be a volume issue on your computer.
Okay. And then again, as we said, the living trust avoids probate proceedings if it is set up correctly and all assets that need to be in it have been transferred into it prior to death. The cons to a living trust, there's more work and expense up front. We have to retitle practically all of your assets, every bank account that you own, your real property, which can get expensive, especially up front. You also have to run it as a separate, you have to run now that you own a trust, right? You have to run it separately. It also does not avoid the work of estate administration and tax reporting. There's a misconception that a revocable living trust means that, your creditors can't come for any of your money ever and that you don't have to pay taxes. That is a true and honest misconception. The revocable living trust does not do any of that. You still are liable for taxes owed, and it does not allow any additional protection from creditors. Administering a living trust is usually not cheaper and easier than probate in Washington. Opening probate is relatively inexpensive. And again, with non-intervention powers, you're really not checking in with the court very often. You have attorney's fees if an attorney is helping you through probate, and you have some other fees that come up. But for the most part, administering the living trust just to avoid probate, you're probably not coming out on the right end of things monetarily.
All right. Any questions so far? I think we're doing okay on time, so I'm gonna keep going. All right, let's talk about the non-probate asset. I had raised the red flag earlier that despite all your best efforts to get your will updated and your living trust updated, there are a few things that might still be out there that are passing by other means. Those would be life insurance, for example, retirement accounts, IRAs, 401ks, 403bs, SEP IRAs, joint tenant with right of survivorship account, transfer on debt, payable on debt, annuities, HSAs. That just surprised me this week. We had a decedent we didn't know had an HSA, and it kind of came out of the woodwork with a few $1,000s in the account. Transfer on death deeds. These are all things that could have been set up at some point by the decedent. Or maybe the decedent didn't ever actually get around to designating beneficiaries on these accounts. Doesn't matter. In the case of an IRA, each IRA account would have its own rules about what happens to your qualified retirement account after you die. So it might not be consistent with your estate plan. And particularly if you had a divorce, for example, make sure you go back and check these beneficiary designations and look at all the titling on your accounts, that it is correct and consistent with your wishes. A transfer on death deed is available in Washington to transfer real property outside of probate. But as Keara mentioned, it has to be done carefully. It can cause a lot more problems than good if it's not done correctly and kept current. Folks, their situation changes, their wishes change over time, and that transfer on death deed might still be out there on the record, even though you forgot that you did it a long time. So important, my bold-faced reminder for all of us: review your financial statement, review your assets regularly, review your beneficiary designations. Also, with your estate planning attorney, if you have one, and if you don't, think about, is it worth sitting down with someone? When was the last time you went through all of this to ensure that you have a plan in place that you're happy with? Because if you don't have a plan, the government and or your financial institutions has one for you, and it might not be what you want. Estate taxes. Again, I have their entire presentation on this. We're just going to gloss through this a little bit so you know what to look for, especially if you're in the middle of an estate administration process. What is an estate tax? Sometimes clients will refer to it as a death tax. Essentially, this is the tax imposed on the transfer of assets after a death. What's included in the taxable estate? Really everything that the decedent owned or had an interest in. So the obvious one is the assets that are in the decedent's name. And then the revocable living trust. As we mentioned, that is not a tax saving trust. So assets in your living trust are still part of your taxable estate. The taxable estate also includes 50% of all of the community property that the decedent owned with their spouse, even if only the spouse's name, the surviving spouse, is named on the account. If it's considered to be marital community asset, 50% of that asset will be included in the taxable estate of the decedent spouse. Non-probate assets that pass outside of the will or living trust, those are still included in the taxable estate. Life insurance policy, including the death benefits if the decedent passes away. If they were the owner on that policy, it's included in their taxable estate. And I'm going to throw this one in here, although it doesn't come up that often, but assets over which the decedent had a general power of appointment. That's a bit of a fancy term, but essentially, remember, if you have a trust that somebody else funded for you, you're one of those lucky folks who have the trust fund that benefits you, you might actually, those assets might be taxed in your estate. And that's something that your estate planning attorney should be aware of if you're working with someone. Okay, I'm going to pass this over to Keara to get a little more in the nitty gritty. And I also would add that we didn't put this on the slides, but if you are a fiduciary on an estate, your personal representative or a trustee under the living trust, keep in mind that the deadline to file these estate tax returns, if one is required, is 9 months after death. There are some extensions available and such, but just that 9-month mark comes up kind of fast. So we tell you, after a death, you don't need to panic about anything, but you do at some point need to sit down and meet with your tax advisor and a qualified attorney if you have a larger estate in particular.
All right, so I'm going to throw a lot of numbers at you. Please bear with me. When we talk about our federal estate taxes, a lucky few, they matter too. Each individual person gets $13.99 million of lifetime exemption from the federal estate and gift tax individually. So if you're a married couple, we can double that number as far as your estate is concerned. This amount is indexed annually for inflation. It is also set to sunset in the end of the year if that happens, but nobody really knows if that's going to happen or not. So it is a flat rate tax of 40% on excess above the lifetime exemption. So if you have given away more than your $13.99 million in lifetime gifts or your estate together, then it is a 40% tax on everything above that. It does not include your annual exclusion gifts of $19,000 each per person. For this year, that again bumps up annually for inflation. And then, yeah, it also, as I said, includes transfers after death, generation skipping transfers. So this would be any gift that my slide went away. Any gift that you're giving to someone who's not your child, let's say from a grandparent to a grandchild, or I believe that the rule is actually 30 years, there's a 30-year gap or something of that nature. They're subject to an additional generation skipping transfer tax. It is also 40% and it is tacked on top of. So it is in addition to any federal that you're paying. And that exclusion is also 13.99. For Washington, we are looking at much smaller numbers. As of yesterday, when Governor Bob Ferguson signed it, the exemption in starting July 1st of 2025 will be $3 million. So each person will get $3 million of estate tax exemption. That is the amount that if your estate is over that value, then it is subject to tax. If not, we're okay. Lifetime estate tax planning is required if married couples want to use both exemptions. The general rule is that you're going to use your unlimited marital deduction to leave everything from the first spouse that passes away to the second spouse. We have to opt out of that rule by using your exemption in a multitude of ways. Generally, we use marital trusts to do such things. There is a graduated tax rate. They again recently changed as of yesterday, but starting in July 1st, 2025, and it'll be a 10 to 35% depending on how much you are over that 3 million per person. We do not tax gifts in Washington, lifetime gifts in Washington.
Yeah, and that no tax on lifetime gifts in Washington. I boldface it because that's one of the best tax planning tools that we have here. Is that Absolutely. While we have a federal gift tax, you don't pay federal gift tax until you've used your entire lifetime exemption of $13.99 million. I think that's another misnomer I hear a lot, is that I can't gift more than $19,000 this year as an annual exclusion gift to my kids and my grandkids without paying gift tax. Well, you're not going to pay gift tax to the federal government unless you've gifted $28 million between you and your spouse, right, in your lifetime, and file gift tax returns for that. So that's something we talk a lot about with our clients and their tax planning. The other piece I was going to add that isn't on the slides here, but that generation skipping transfer tax, I wouldn't lose too much sleep over it because we plan, hopefully at this point, if you're at this number or above, we really hopefully have been doing some good planning, and we can avoid that generation skipping transfer tax in most cases through good planning. And there's also no generation skipping transfer tax in Washington. That's just a federal concept for now. And last but not least, this number, I think this 13.99 million, Keara mentioned it would be maybe sunsetting at the end of this year. What we're saying is that number is going to be cut in half at the end of 2025, unless Congress extends the tax cuts that have been in place for about the last 10 years, I think. So we just don't know what is going to happen on that front, but for now, we've all got 13.99 million to work with. Okay, post-mortem planning. This is something that I just want to make sure you flag it, especially for those of you who are financial advisors in this presentation. I think there's a few of you. I know obviously it's here in Jordan, but post-mortem planning, if you have a married couple and the first spouse has died, I'm going to put it in boldface red type here. Talk to your estate attorney before retitling the asset. Because if assets get retitled to the surviving spouse without any other discussion, we have lost a whole bunch of potential opportunities to do some good. And if there is a good estate plan in place, we should be able to, even if there's not a will, there's still some things we could do. So let's just talk about it. So good point. A timely disclaimer is something that we sometimes use if the spouse has more than enough to live comfortably. Maybe they don't want to claim their entire inheritance. Maybe they would like the kids to get some of that sooner. We can do a disclaimer, but it has to be signed within 9 months of death. And if we've already retitled assets into the surviving spouse's name, we have lost that planning opportunity. This applies primarily for brokerage accounts, bank accounts that might have been set up as a transfer on death or payable on death, or even joint tenancy with right of survivorship. Those are the ones that I think folks tend to rush to retitle. We might also file a federal estate tax return. Even though there's no estate tax owing federally, we might file the return because then we can preserve the first spouse's federal exclusion, that 13.99 million. We can bank it basically for the surviving spouse to use. We can pick and choose what assets we put into the marital trust, but only if they haven't been retitled yet. And we can do a few other things that I'm not going to get into the weeds here, but there's just a lot of work that happens after a death. Most of this would be done by the accountant and the estate planning attorney or the estate administration attorney in partnership with your financial advisor, folks managing your brokerage asset and retirement accounts. Key takeaways. Keara, do you want to sum this up for us? I think we're coming up on our 45 minutes, so I'll let you wrap it up and then we can take some questions.
Sure, absolutely. So we've gone over a lot. It's very dense material. I think some key takeaways: probate in Washington State is not scary. We hear it a lot in, you look it up online, a Google search, social media, avoid probate at all costs. In Washington State, that is just not the case. Washington doesn't take 10% of your estate value. It doesn't do a lot of these things that some states do that make probate scary. Washington probate is not scary. And if you don't have a better reason to use a living trust than just probate avoidance, we need to talk about, or, you and your estate planning attorney needs to talk about your goals and what's truly important versus not so important, right? It's important to regularly revisit your personal planning. If you purchase out-of-state real estate, that is something that your estate planning attorney needs to know. We won't know unless you tell us, right? So we have to know when you do things like that so that we can help plan. It's also very important that when you're regularly revisiting your personal planning, that you're talking to your, trusted advisors and estate planning personnel every 3 to 5 years, unless something big happens. Let's say you inherit a large sum or a family member that you planned on leaving either in charge of things or receiving things as the beneficiary has passed away or gotten divorced. Life changes. It's really important that when something big happens, you let your professionals know, even if it is an email that says, hey, this happened. Do we need to come see you? Most professionals are always happy to take those, and we'd rather have you ask than not. And then we are in a pickle later. It's also important that you regularly revisit your non-probate assets, those IRAs, retirement accounts, life insurance policies, to make sure that they align with your final objective that's reached in your revocable living trust or in your will. We want your estate plan to all work cohesively together, not against itself. And your beneficiaries that are listed on those non-probate assets, that's an important aspect of that. Know what you own and how it's titled. That's something that you just have to keep doing as time goes on, right? You need to know what you own and how it's titled. If you're running a revocable living trust as your estate plan, when you purchase new things and it can be titled in the estate, ensure it's done. You buy a new house, don't buy it in your name alone if you have a revocable living trust. That's just asking for an unnecessary probate that could have been avoided. It's also really important for the person that comes after you, the person that picks up this project after you pass away. If you know what you own and how it's titled, and they can find that with that letter of instruction that I'm going to talk about in just a second, that is way easier for them to pick that up and get started. Then they don't have to rifle through your mail and try to piece together all of the different pieces. You've given them a roadmap to a certain extent. This letter of instruction, I would strongly, I think that it's worth considering writing a letter to your personal representative, a successor trustee if you have a living trust, as well as your agent under your financial power of attorney that says, here's what things are, here's where you, or even here's where you can find things. I keep, my records that are relatively updated in my safe. Please go look for those things. Have someone who knows where to find the necessary documents, where to find important documents, how your assets are held, or what bank you bank with. Someone else needs to be informed. It's not very nice to drop something off in someone's lap and say, I really hope that you can find what happens next because you can't call me and ask anymore. And then another thing that is incredibly important is don't retitle assets after a death before talking to a qualified attorney. Even if you are the surviving spouse, your spouse has passed away, you have access to all of these things. Take a second, take a breath, and talk to someone that you trust who is a qualified attorney in that area. They might need to use those funds for tax saving maneuvers or other things. And if we start to retitle assets and take control over them and transfer them into our own accounts, we're really hurting the plan more than we are helping the plan that the decedent has left for us.
And I would add in the letter of instructions, another thing that's helpful to know is who are your medical providers. This is probably more for not the surviving spouse, but let's say if you have a friend or a professional fiduciary coming in to as your successor, as your personal representative, successor trustee, or your agent, your attorney, in fact, who might be acting on your behalf during your lifetime under a power of attorney. All this information about who are your medical providers, where do you store your passwords, who's your estate planning attorney, who's your financial advisor, who's your accountant, where do you store your documents, and who has the key to the safe, or who knows where the key is. Like, these are things that just, it seems sort of obvious, but actually folks might not know. So write it down. I know Alan's nodding. He probably reminds everybody of this too. But these are the things that really make life easier for those folks that are going to be in charge down the road. And they don't spend the next year of their life finding in your mail bills popping up that we had no idea you had an account at this place, and we didn't know, and so that happens, unfortunately, and it's just not very much fun. So the more organized you can be, the better.
And I'll just throw it out there. I sometimes jokingly say this, but I mean it in all seriousness. If someone owns a physical asset, like an ounce of gold buried in the backyard, that map, call it a treasure map if you want, is really important. So I can't stress enough how important that is. And that's not like a legal document. This is just something that you leave for your heirs that will be just as important in some cases.
That example came up in a meeting I was in last week, and it was somebody had buried their bullion under their, I think on her deathbed, she told her children to turn over the potato bed. Well, they didn't really understand, but she hadn't lived in her house for years, because they went back and they were cleaning out the house, and they sent one of the grandkids out to turn over the potato beds and found a bunch of silver or something, So they almost accidentally gave all of that to whoever bought the house next. People don't know they can't help you. So there you go. Those are our key takeaways. We went just slightly over, but we've still got almost 10 minutes for questions. And also I'll leave our information up here for a minute if you want to copy down and give it follow-up questions for later. We're happy to. Phew. All right,
Well-
question?
I want to just quickly kick this off and let me know if this is one of those questions that might derail us. We can take this offline. But I was speaking with a couple and we're trying to do some planning in thinking about testamentary trusts and the Washington State estate tax exemption amounts. I've used bypass trust, credit shelter trust, disclaimer trust. I've kind of used these interchangeably. Is that okay? Is there really big distinctions between those three different trusts, or are they all kind of the same?
Karen, you want me to take this one? Sure, okay. So I would say a bypass, somewhat interchangeable. I know what you mean. We tend to call it the marital trust in our planning, just because I like that it's obvious to me when I say marital trust that my spouse is somehow involved. It's basically, this is a trust of which your spouse is the primary or sole beneficiary during his or her life. A bypass trust, a credit trust, an exemption trust, those three typically refer to a trust that actually those trust assets will not be taxed in the surviving spouse's estate. A disclaimer trust is often, that's also true for a disclaimer trust, but a disclaimer trust is funded differently. It's not a requirement that the disclaimer trust be funded. The surviving spouse has to take an affirmative step to disclaim some assets to actually transfer into that trust after the death of their spouse. It might be that all of those are exemption trusts, that they're exempt, but they might not be exempt for both federal and Washington state taxes. So that is also sometimes confusing. You can have a spousal trust, a marital trust that's taxed in the surviving spouse's estate for federal purposes, but not for Washington, or not usually the other way around. But it can, those can be, they can get a lot more complicated. But I think you're okay, Alan. I think all those terms, basically, I get what you're saying. It's the trust for spouse. I just like to try to use English that I'm going to turn off my screen share. I like to try to use terms that have some relationship to what the trust is doing, who it benefits.
Yeah, thank you for clarifying. Yeah, Jordan, do we have a
And
question?
it looks like we do have a question from Patsy about the estate taxes. Does it matter whether items are listed in the will or living trust or not?
When it comes,
You're on mute.
pardon?
Oh, I hear you now, Patsy.
I'm just gonna let Keara take that one.
Okay, and I was just going to clarify what I was wondering, and that was in the midst of taking notes, is whether something's under the umbrella of the trust or not, or the will or not, does that affect taxes, estate taxes?
So no, it will generally not. Yeah, it'll be taxed the same whether you have a will-based
Right.
plan or a bookable living trust-based plan.
Thank you. I need to fix my notes.
Any other questions?
I have one.
Great.
So 7 months ago, my father-in-law passed away, and we started down this road as newbies, my wife and I did. And we've learned a lot along the way. And now we are taking care of my mother-in-law's estate. My wife is her executor of her estate. And as we keep going through this, we keep learning more and more. And this is especially a great presentation for all the basics, I think. So really appreciate Financial Insights doing this and putting this together. So very much appreciated. And really, my only question is, will this presentation be available to us afterwards?
Yeah, great question. Yeah, we recorded this so that we can put it up on our YouTube channel. So all the
Oh.
information, the presentation will be available probably in the next week or so, and we'll share that with everyone that joined us today, and then of course with all our other clients. But yeah, this will
Perfect.
be made available.
Perfect.
I have
Thank
a
you.
question. Is there a way to get a copy of the slides that you used on the presentation? For those of us who couldn't write fast enough.
Yeah, in addition to putting up the video, yeah, we're happy to send out the slide deck. Amanda, Keara, I'm assuming you're okay with that. Yeah, we
Would
can
you
send that
send
as
a
well.
email with the files?
Yep, yeah, we've got a PDF of the presentation, so we'll share that as well.
Thank
Yeah,
you so
perfect.
much.
Of course.
And it looks like we have two more questions. One from Cecia is, if there's a marital trust with the spouse as the primary beneficiary and their child as a secondary beneficiary, does the child get taxed, or is it all tax-free for anyone listed on the trust?
I would say, first of all, I probably wouldn't refer to that as a marital trust. The children are also, I think it depends on what you mean by second beneficiary. I think you might be saying that children inherit only after the surviving spouse has passed. And if so, that's a marital trust. If the children are also beneficiaries during the surviving spouse's lifetime, that is not going to be what I would generally call a marital trust, credit trust, shelter trust. In that case, there's still no tax to the kids from an estate tax perspective. So there's different types of tax, right? We've got estate taxes are paid by the estate, transfers to your kids outright or in trust. Even if the children are just one of several beneficiaries of the trust and your spouse is among them, that is considered a taxable transfer at death. So you can leave your spouse as much as you want outright or in a marital trust that meets certain criteria without triggering estate tax. But once your kids are involved, that does start to count against your estate tax exemption. The estate would pay the estate tax. Your children, eventually, when they inherit from the trust, if it's coming to them as a distribution after lifetime, typically not a taxable transfer. There could be some income tax implications, though, upon distribution to the trust. So that would be something to talk to the accountant about. Okay, other questions? I guess I'll just keep going because we're running out of time. Is there a specific time frame to close out estates other than the 9-month deadline mentioned? I want to say yes, but estates can sometimes take a very long time depending on how complex the assets are and a host of other reasons. Typically, we file an estate tax return within the 9 months, or maybe we extend it by 6 months. We file a late return for certain reasons, but it takes a while for estate tax returns to be reviewed and accepted by the taxing authority. And during that time, we would generally recommend keeping the estate open if there's a probate. Just leave it open until we get closing letters from the IRS and the final letter from the Department of Revenue in Washington that the estate returns have been accepted as filed. And there are a couple other things, but so I would say there's no hard and fast deadline on when an estate is completely finished. It really depends on the complexity of the assets and the tax reporting timeline. How reliable are online will platforms? They are popular these days. I suspect some are better than others. I'm always wary of DIY planning because we tend to see more problems than good come from doing it yourself. One size fits all just isn't typically true, unfortunately. And there's so many different variables that can come up. Taxes, blended families with children from different relationships, capacity concerns, all sorts of out-of-state assets that are not properly accounted for. I just take it with a grain of salt. I think you get what you pay for in this area. And if you're going to go online and do it at your own, at a discount, it might be fine. Got a really basic bread and butter estate, or you're a single person leaving everything to charity, it might be fine, but it sometimes ends up costing more on the other end. The estate ends up being much more expensive to administer than if you had done some good planning up front. To use a special needs trust, does the brother need to be officially diagnosed with a special mental or physical need? Yeah. You can set up special needs trusts for someone who does not have an official diagnosis. It's based on a whole bunch of factors, whether that would be the right to it. Okay, I think I got through all the questions. Did I answer everybody okay? It's 4 o'clock.
Well, with that, I just want to say thank you everyone for attending. Thank you so much to our presenters, Amanda and Keara. And we're going to follow up, like I said, with a recording of this and the slide deck. And then if you have more questions that you think of later, feel free to reach out to me or anyone here at Financial Insights, and we can definitely point you in the right direction, and Amanda and Keara too as well, our resources. So thank you. We're going to have another Wisdom and Wealth later in the fall. And yeah, everyone get out there, enjoy the great weather. See you later.